Alice here with part 194 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will go over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. Now we get to go into the order regarding omnibus motion. This is the about face that the judge takes after having actually read the motion. Obviously, my mindset was relieved. I mean, I was already put under a whole bunch of stress because she was basically forcing our son to go and see my ex, despite us not having a clue where she lived. And luckily, that didn't happen in time because this order came down and allows me to withhold visits. It suspends our visitation, even though it doesn't say that in the title. I mean, that's kind of a big enough thing that you might want to put in the title of an order. But anyway, all of these crazy making statements that she made in that previous order denying ex parte motion have been resolved. And so it was like a ton of pressure off my shoulders. And it's just going to be one of those things that I think you're going to have to see for yourselves. So let's go straight into what the judge has filed. Here we have the order regarding omnibus motion, and the court has reviewed all the papers and orders associated with my omnibus motion to establish continuing duty to disclose, etc., etc., etc. Finds and orders as follows. Again, the court's making findings of fact without having held an evidentiary hearing, but let's go ahead and go through these anyway. So, number one, parties are the parents of the minor child. Share joint legal custody. So this is just going through the history. It's a summary statement of the custody designations. Next, we have her acknowledging the filing of the omnibus motion. Next, we have my request that the court establish boundaries and procedures for events. Next, we have, let's see here, the omnibus motion. I'm including a motion to allow supervision of phone communication, stating that my ex was ordered daily phone visitations with the child and that she prefers to speak with the child in private. And I'm alleging that the child notified me following a telephone conversation that she instructed the child to answer the mental health provider's questions with a code word. I wonder how she deals with that. I think she still screws this up in this order, but we'll see. At least that little piece. My ex's attorney responds saying, yeah, we can't even talk to her. Okay. And then we have my reply that my ex appears to be unable or unwilling to communicate with her own attorney. Accordingly, let's see here. I'm alleging that my ex's opposition does not necessarily preclude the court from exercising DCR 13.3, and I'm urging the court to avoid setting a hearing on this matter merely to offer my ex an opportunity to appear and respond, which she won't do. Let's see. Conclusions of law. She goes into DCR 13, which allows the court to construe my ex's lack of an opposition to, you guys know how this works. We went through this with the last order. In the present case, my ex's attorney filed an opposition to merely avoid the admission of the allegations and, well, in an effort, keyword effort, to avoid an admission of the allegations and requested relief outlined. The court notes that my ex's opposition failed to provide any legal authority regarding the issues presented or address the allegations made by me. There's a strong judicial policy favoring decisions based on the merits. My ex has made this impossible in this case as she has failed to communicate with her own attorney and that she has failed to respond to my motion. The court reiterates that joint legal... Why are you saying something that nobody listens to? Like, you're just wasting space on a piece of paper. For the 15th time, joint legal custodians have an obligation to share blah, blah, blah. Okay, we know that. Do something about it. Due to my ex's failure to make information regarding... Wait, what is this here? So she shall provide to me a physical address where she resides and can exercise visitation within the next 10 days. Oh, look, she gives me a continuing duty to disclose. Finally. I love how she says 10 days after relocation. I don't understand why they wouldn't, like, people know when they're going to move usually. You should be giving them notification 10 days prior relocation, not after. Anyway, due to her failure to make information regarding health insurance available, let's see, she's ordered commencing January to pay for one half the premium incurred to me. And to the extent that she's failing to pay child support, I'm entitled to seek the assistance. I already did this. This is already happening. Okay. What else do we have here? Parties may not monitor telephone conversations between the other parent and the minor child. However, she's ordered to not interfere with because she complies with orders all the time, right? So here's another example of the court facilitating abuse and neglect. I've just alleged that she doesn't listen to what the court is saying. And so the court's response is to order her, again, to do something that she's already not listening to. Once again, facilitating abuse and neglect. Next section here. Given the evidence of my ex's failure to communicate, the court adopts my suggestions to wit. School volunteering. Okay, so let's see here. I can volunteer in the courtroom, on the classroom every odd year, and then my ex can volunteer in the classroom every even year. Let's see. Myself and my ex shall be entitled to volunteer for school-wide events. Looks like the same thing, alternating even and odd years. If the event is both a classroom and a school-wide event, then the parent who is entitled to classroom volunteering is entitled. Both parties shall be entitled to attend ceremonial events. The parties shall refrain from contact with one another at these events and shall avoid embarrassing the child, which is, again, another order that's a waste of space. Medical and health appointments. Based on the unrefuted depiction of scenes made at the doctor's office, I shall have sole rights to attend visits. Thank you. Finally, she's banned from going to medical and health appointments. This is how you solve the problem. Okay. Parent-teacher meetings. Each parent shall schedule their own meetings with the administrator. Thank you. Another solution, another obvious solution to high conflict child custody cases. Now we can caucus with the teachers. Compliance with the order. Although as noted in the January 11 order, I did not have the right to refuse to comply with ordered visitation. I have sought an appropriate amendment to that order by his motion. No, I didn't. Until my ex discloses her address as previously ordered by the court, she shall exercise no in-person visitation. No. So here's where she broke the law. She says here, I sought an appropriate amendment to the order by my motion. I didn't. Read my motion, guys. It doesn't say in there that I'm trying to suspend her visits. So this is the judge breaking the law in my favor this time, which is nice since she broke the law in a way that was adverse to me last time. This is the ultimate CYA, cover your ass move by a judge. She won't admit that she screwed up. She won't admit that she was wrong. She won't admit anything. She's trying to find a way to make it look like this is totally proper. Like this is just how things work in the court system, but it's not. Once the judge has entered her final written order on that previous ex parte motion, she can't go and change that now. She's stuck. If the judge wants to fix that ex parte motion, the judge has to file her own motion and give my ex the right to oppose it. Due process protections have triggered. As soon as the judge entered that final written order, she screwed herself because now she's bound by the request that I made in the omnibus motion, which does not request a suspension of visitation. So the judge here is violating my ex's due process rights to fix her own screw up and probably hoping and praying that my ex doesn't have, well, she knows she doesn't have an attorney because the attorney withdrew, that my ex doesn't know how to file an appeal and actually attack the judge for doing what she's doing now. Totally improper, inappropriate, and what can I do about it? I'm not aggrieved. I can't file an appeal for my ex because the judge is violating the order in a way, or violating the law in a way that is beneficial to me. So, I mean, take what you guys will from this, but this is the most, in my opinion, disgusting thing that this judge could have done. She should have just granted that ex parte motion. And by not doing that, she put herself into a situation where she can't fix anything without breaking rules. She's forced herself into a corner where she has to break rules to protect the child. because for some reason it's dawned on her at this point in time that none of this makes any sense and I need to fix it. And so she's making it look like all of a sudden now I'm doing what I'm supposed to do. She's basically saying, now that Alex is doing everything the way he's supposed to, now I can give him what he's asking for. But all she's really doing is she's acting like a politician, not a judge. She's trying to protect herself, her mistake, without actually admitting that she did anything wrong in the first place. And there is nothing that I've done now that requests an amendment to the court's order. Nothing at all. So this is the judge on her own, once again, saying something that is untrue to make it seem like her order now is justified. I appreciate that she's fixing her own mistake, but to me, I mean, my opinion had already gone down so much from all of the other things that she did incorrectly, including the attorney fee sanctions. And now, when I read this specific paragraph here, to be completely honest with you guys, this was the moment in time where I thought she's just like Judge Chuck Weller. All of the mistakes that she made up until this point, I thought it was just a judge who just didn't know how to do her job. I thought she just was ignorant. She didn't know how the law worked, and she was just screwing up randomly. Like, she just didn't know. You know, I can deal with that problem. But when I read this specific paragraph here on page 5 of this order, this was when I got the clue that she does know what she's doing right now, and she's doing something that she shouldn't be doing, but she's doing it anyway to try and fix a mistake that maybe she wanted to fix the mistake because she cared about my son, but more likely, I think that she fixed the mistake because she was worried that I would file a notice of appeal. And most likely I would have, because the provision concerning the paying my ex back for all those flights, that would have aggrieved me. So I would have done something about that. In any event, I can't do anything about that other screw up now because the judge has rectified the problem. If my ex filed an affidavit asking for those monies, maybe I could, but she never files it. So my ex never files the affidavit, and I'm not aggrieved in any way, shape, or form because I don't have to pay any money. I don't have to give any makeup time, and I got the suspension of visitation. So if I had filed an appeal, I would have lost. They would have just said, you're not aggrieved. There's nothing that we can do to you because you're not actually harmed by the judge's errors anyway. So I've talked about this before in the video filing an appeal. You can watch that specific video. You should also watch the video Harmless Error, because in there I talk about the notion that judges make mistakes, but if you aren't harmed by that mistake, the appellate courts won't do anything about it. They'll just leave it. So if you watch those two videos, Filing an Appeal and Harmless Error, you'll realize what I'm talking about at this point in time as I go through this specific order. This paragraph here has made it so that I can't do anything about that previous mistake because she's fixed her own mistake. Now, I really don't like that she's characterizing me as suddenly having complied with something that isn't true. I complied with it with the original motion, and in fact, I'm not even requesting this relief now. But if that's what the judge has to do to make herself feel better and to look like she's following all the rules and look like a good person, that's fine by me. But to me, this was dirty. This is a very dirty move. But let's go ahead and move on. Let's move on. There is the standard boilerplate here, penalty for violation of order. This is just the statutes in Nevada require every single court order in a child custody case to state this. It's like verbatim stated in every single order, and it just states that you can't run off with the kids, child abduction is a felony, etc., etc. Certificate of electronic service indicating under Rule 5 that this document was electronically served on my ex's attorney and mailed to both myself and my ex. Next, we have the request for submission. This is, okay, so remember how earlier I said maybe the attorney doesn't realize he referred to the wrong motion to withdraw in his last request for submission. So he just now filed another request for submission, but this time he refers to the correctly filed January 20th amended motion to withdraw as counsel of record. Guys, if you want to learn more about the request for submission, please watch my video on the topic, request for submission. We have the affirmation indicating no social security numbers in this document. We have certificate of Rule 5 service indicating that this request was mailed to both myself and my ex. Order permitting withdrawal of counsel. So the judge has reviewed the attorney's amended motion to withdraw as counsel of record. The court has reviewed the above referenced motion, and the court has ordered that the law firm representing my ex is allowed to withdraw. All further pleadings and notices, no more pleadings are being filed in this case. So the judge doesn't know the definition of a pleading. If you want to watch my video on the topic pleadings, the pleadings are already filed. There aren't going to be any more in this case. If you want to know, Yeah. So anything else that's filed in this case, guys, is post-judgment, and it's going to be another paper. It's not going to be a pleading. I explained what the definition of a pleading is in Nevada in the video pleadings. I'm not going to talk about it now because I already covered that. Anyway, moving on. Parties are notified that, okay, same thing. It's that same boilerplate that you can't run off with a child. And then same thing. Okay. Certificate of Rule 5 service indicating that this document was served electronically upon the attorney and mailed to both myself and my ex. Renewed motion for order to show cause. So here I am renewing the same old motion for order to show cause that I had already filed. And it's got my affidavit. I think this is the same affidavit that was, I'm not going to even go and check. Hey, if somebody wants to, can you go back and check the original motion for order to show cause and post in the comments if it's the same affidavit that I just pasted it here again for the judge? Anyway, I mean, guys, this affidavit is it's gonna be verbatim what's already in that motion, even if it's not separate or I don't know. But these there's no new allegations in here, not a single one. It's a copy paste of the factual background in that motion, or it's a copy paste of the same affidavit, one or the other. So nothing here is new. There are no new assertions here at all. It's all the same stuff. As with the policy on my docket series, I don't go over documents over and over again. If you'd like to make sure that there's nothing in there that was relevant, you can go down into the description below, click on the link for yourself, download it, read it, and if you think that there is something that I should have covered, go ahead and mention it down in the comments below. But there's nothing really. If you want to know more about why the affidavit's required, you can watch my video on the topic contempt of court. But I mean, the affidavit was there, so it's not like I really didn't file it and I had to file it. It was already there, and I just wanted to avoid an appeal on this issue, and I just filed it again for the judge. Rule 5 certificate of service indicating that this document was mailed to my ex at her P.O. box. Then we have the motion opposition notice indicating that I did not have to pay a $25 filing fee to file this. List of exhibits. We have a child support ledger. Child support ledger, exhibit 1. Okay, it's just math. I mean, if you guys want to, you can look through all this stuff, but it's just a bunch of numbers. Attorney fee offset, that's going to go away. So 1715.64, it says here it's pending appeal. That's going to reverse, but I don't really have anything else to mention on this. Ultimately, all of this money gets seized, so I do end up getting all the money. It just takes several years, but it's none of it is required through contempt of court. It's all acquired through execution and asset seizure. Go figure. I wonder why the government uses it, because it actually works. By the way, guys, that is a video topic. You can go ahead and take a look at my video on the topic, execution and asset seizure, to learn about how that process works. And I know I've gone through it a few times on this, my docket series as well. Okay, WDFCR 34, notice of pending proceedings. So you've already seen me file something similar to this in the other case, in the FV16 case, and now I'm filing the same notice in this court case, letting this judge know of the enforcement proceedings, and that's what I'm doing here. FV16 00031 is the notice of intent to enforce filed by the district attorney. Rule 5 certificate of service indicating this document was mailed to both my ex and the district attorney. Notice of entry of order. Now this is interesting. It's interesting because usually the attorney who wins will file the notice of entry of order. So here I am recognizing that my ex's attorney failed to file the notice of entry of order on the order denying ex parte motion. So I'm going ahead and I'm entering the notice of entry of order on my order regarding omnibus motion, and I'm also going ahead and doing this for that attorney on the order denying ex parte motion. The reason that I probably did this was because I was still considering whether or not to appeal it. I was probably still thinking about it. And then we have the the order denying order to show cause as well. So I'm entering notice of entry of order on all 3 of these orders. And I'm sure that the reason I did that is because I was thinking I might appeal these. So I didn't ultimately end up appealing either of these 2 things, but I was thinking about it. Oh, and if you want to know more about why that's relevant to what I'm talking about with this filing, watch my video on the topic notice of entry of order, because in that video I explain how this triggers the process for the deadline to file an appeal. Rule 5 certificate of service indicating this document was mailed to my ex. List of exhibits, exhibit 1, and it's just the order that we've already gone through. So I'm not going to go over that again. Same thing as before, guys. If you want to, go through the rest of this document, just go down into the description below, click on the link, download it for yourself, and take a look. Going into the aftermath, I filed, it looks like 1, 2, 3 documents. They were all free filings, so I incurred $0 in costs. My ex's attorney filed 1 document. It was also a free filing, so he incurred $0 in costs. I don't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably reviewed the order regarding omnibus motion. It's his duty to do so as the attorney. And he would have prepared the request for submission and reviewed the court's order allowing him to withdraw. I think all of these documents, he was pretty much, I think, for the most part, checked out at this point in time. So I would say 30 minutes total for all of that. At the rate of $250 an hour is going to come to $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.